As I have already mentioned, delegated or subordinate legislation refers to the rules and regulations made by the executive authorities under the powers granted by an enabling act or an act conferring power. The executive authorities can be existing institutions like ministries or various departments who are empowered by a statute conferring power, or they can be commissions or authorities established under an enabling statute. The interpretation of the delegated legislation is quite straightforward. The delegated legislation and any interpretations of the same must be intra-vires. That is, it should be within the scope allowed by the enabling or the empowering act. It cannot exceed the scope and cannot contradict the main statute. The court established this principle of intra-vires in the Express Printers versus Union of India case. The interpretation should be reasonable and should be in accordance with the purpose and the objectives of the enabling or the empowering statutes. The interpretation should be clear and unambiguous. The delegated legislation should have been made as per the procedure established by the main legislation and should not contradict any constitutional provisions. If all of these requirements are met, then the delegated legislation, that is, the rules and regulations, should be treated as a part of the main act itself, which means that they get equal importance as the main acts and are not just considered as administrative directions which are optional. In the Delhi Laws Act case, the court clarified that there are some limits to what the legislature can delegate to the executive. The court ruled that defining the policies is an essential legislative function that cannot be delegated. Only the powers to make the rules and regulations to implement the policies can be delegated.